Good evening and thank you for joining us on The Last Word tonight. My name is Sophia Wanuna. Great news and huge relief for Deputy President William Ruto and radio journalist Joshua Arap Sang as the International Criminal Court today terminated the case they were facing on crimes against humanity. But as the congratulatory messages flowed in, the very important question remained and was asked by many. When will justice for the post-election violence victims be served and be seen to be served? That is a discussion we're going to be having with my guests tonight on the show. But let's get started with a reaction from journalist Joshua Arap Sang on receiving that ruling from the ICC.
I'm just delighted that I have my freedom today. This is what I've been longing for the last 6 or 7 years. God has seen us through today. I'm so happy I have my freedom. That is what matters. I want to thank God so much. I want to thank my lawyers, led by lead counsellor Katwa Kigen. They have done a wonderful job. They have done all that is possible. And now we are free with Bosekia. My lawyers have been great support. I just want to say thank you, God. Thank you, Kenyans. Thank you, everyone that has been praying for us all this time. You are great. I love you, people. I love you, Kenyans. I love you. Thank you, God. I'm free. Free. Yes, I'm free. The lies are gone. I have my freedom. That is what matters. Thank you, God. Thank you, Kenya. Thank you, President Uhuru. Thank you. All this has been made possible because of Kenyans who have been praying for us. They have done what is possible to make us free. I was innocent. I am innocent, and I will always remain innocent. I said I was an innocent journalist, and that has been proven today. Thank you, God. Thank you. Let it just be there. I'll give you. We will give you a comprehensive statement on Thursday afternoon.
An emotional Joshua Arap Sang there on receiving good news for him. Termination of those charges on crimes against humanity by the ICC years after those charges were confirmed in 2012, so 4 years since that process began. Let me just take you down memory lane in as far as those others that were charged and the charges were confirmed, those who were not, and that this being the final straw in as far as ICC is concerned. However, we never know, prosecutor might just appeal, but that is a conversation we'll be having shortly. So January 23rd, 2012, we saw ICC confirming charges against Ruto, Sang, Uhuru Muthaura, and charges against Muhammad Ali, Henry Kosgei as well, were later dropped. Let's move on to the next slide. Remember the charges also against Francis Muthaura on March 2013, who was the head of the civil service, as well being dropped. So these were the ones who got their green light to leave this proceedings and no evidence found against them to continue with the charges and found them released. But for Ruto and Sang, their trials beginning in earnest on September 10th of 2013, just about slightly over 2 years ago. And following the trials beginning, the court then made the decision, of course, we remember recently last year, March, to withdraw charges against President Uhuru Kenyatta. At the time, President Kenyatta had said he would not celebrate his acquittal up until all the cases that were before the ICC were terminated. And today in his statement saying finally that has happened, and on the 16th of this month saying they will be gathering in Nakuru for that celebration. But let's continue on with the Ruto Sang case, because on January 13th this year we saw the court hear the no case to answer motion that was filed in October 2015, last year that is, by the defense team, saying that in fact the evidentiary threshold did not stand that which had been seen during the pre-trial level when those cases had been confirmed. That night was a completely different case, and that did not hold water to warrant a case to continue. And of course then that proceeded on to the office ICC rejecting the use of recanted evidence in Ruto Sang case. This is after the office of the prosecutor had argued that it needed to use that evidence that had since been recanted by numerous witnesses to be able to still continue with the case, saying at the time they had a very weak case, but with recanted evidence they could go on. However, ICC appeals chamber, the pretrial chamber had allowed for that to happen, review of Rule 68, but the appeals chamber refusing and rejecting that recanted evidence be used in their cases. And of course, following that is the big news that came through this earlier this evening, and that is ICC terminating the Ruto and Sang case. Before I introduce my guest to you this morning, let's take a listen. This evening, I beg your pardon. Let me introduce that clip from the officers and officials from the International Criminal Court that read out part of that judgment by the ICC judges.
Trial Chamber 5A of the International Criminal Court decided by majority, with Judge Olga Herrera Carbuccia dissenting, that the case against Mr. William Samoei Ruto and Mr. Joshua Arap Sang is to be terminated. The Chamber considered the request of Mr. Ruto and Mr. Sang that the Chamber find that there is no case to answer, dismiss the charges against both accused and enter a judgment of acquittal. The Chamber also considered the opposing submissions of the prosecutor and the legal representative of the victims and received further submissions during hearings held from 12 to 15 of January 2016. On the basis of the evidence and arguments submitted to the Chamber, presiding Judge Chile Eboe Osuji and Judge Robert Fremer, as the majority, agreed that the charges are to be vacated and the accused are to be discharged.
All right, and that is the ruling there being read out. I want to introduce to you my guest tonight, Elisha Ongoya, who's an advocate of the High Court with us tonight, as well as Kagwiria Mbogoria, who's the chair of the Kenya National Commission on Human Rights. We thank you for being with us tonight. Let's begin with you, Mr. Ongoya, and talk about that verdict and how you translate it to mean, and as far as there are those who argue that no case to answer means that Ruto is innocent?
Ruto was presumed innocent from the very outset, and he remained innocent. He didn't become innocent this evening. The law presumes every accused person to be innocent until found guilty.
Right.
So the question of whether or not he is innocent does not arise.
Yes.
It is presumed. He was innocent from the very outset.
Okay.
What is sure is that he has not been found guilty. But the devil is in the detail. If you listen to the ruling, the judges, both the majority and the dissenting, left quite a bit for digestion by the prosecutor to see what options are available for the office of the prosecutor moving forward with these cases.
Yes, because one of the things, Chair, that the judges said is that intolerable political interference had been found in this particular case. What does that make you thinking as far as these proceedings are concerned? Because interference is not the first time we're hearing that word.
Thank you very much. I think that was a very curious statement indeed. And the judge declared a mistrial due to a troubling incidence of witness interference and intolerable political interference. And I think that is what my colleague is referring to as something to digest for the prosecutor. And I think there was a little window left open that in case of fresh evidence, charges could be preferred. I think there was a little window left open. Even so, I think that when we get to read the complete record of the proceedings and the judgment of the court, we'll be able to make a better analysis of what the innuendo, or some of the things that were packed in that particular judgment.
All right, yes.
There are two things that our viewers must be alive to. Number one, when the Honorable the Deputy President Ruto filed his motion and Sang filed his motion, they sought an order of acquittal. The judges did not grant an order of acquittal. They discharged them. Technically, this has significance.
Okay.
Had they been acquitted, it would have meant that they have been cleared of the charges and no further proceedings based on the same facts can be brought back to court. they were discharged, meaning that the proceedings have been terminated, but further proceedings may be brought against them based on the same facts. Those are, I think, what my colleague refers to as a curious finding that is a subject of discharge. Number two, you realize that there are not less than 3 proceedings still going on at the ICC against Kenyans for interfering with the process of justice. Some of the Kenyans are in the Kenyan courts fighting their extradition, so to speak, to The Hague for purposes of facing those trials. If you look at the controversial Rule 168 that has been a subject of debate before, you will realize that if a subsequent finding is made that such interference did occur, and to an extent any of the accused person had a hand in it, this could reopen the case regarding recanted evidence under a different rule of Rule 168. So it's important. All these are the options that are available, and that's why we're saying there are certain findings in these rulings, both the majority determination that terminated the case and the dissenting determination that thought that the case ought not to have been terminated, that would make any celebration a very cautious celebration.
Yes, because we saw the argument has been, why shouldn't there be processes begun against the crimes on administration of justice?
Yes.
Because that is the interference you're talking about. But there are those who say and argue whether the collapse of these cases is a result of the interference by allegedly the accused and their supporters, or was it a flawed investigation and prosecution? What do you think?
I think at this time we cannot really give a definitive answer to that particular question. I think the prosecution did raise some questions on the process of the investigations prior to the prosecutions, may seem to have left some gaps. However, there was always a lot of, throughout this process there has been a lot of allegations of interference with the prospective witnesses. And that may have interfered with the case. What I know is that for legal scholars, the Kenyan cases are going to leave a very big mark on the ICC and the International Criminal Court. And I think books are going to be written about how the ICC worked before and after the Kenya cases.
Yeah, because there are those who argue, Ongoya, that this was bungled from the beginning. You remember, and we've been seeing his pictures on the screen, then Chief Prosecutor who took on this matter, Luis Moreno Ocampo, came out and said that he'd make an example of Kenya. And there are many who are saying, where is he now? Can he still stand by his words today?
Oh, yes. And as my colleague rightly points out, the question as to which hypothesis is right, whether the case has collapsed because the prosecution incompetently investigated this case, or whether the case has collapsed because some persons of interest to the trial interfered with the evidence that was supposed to sustain the cases, is still a live question out there. None of us sitting in this studio has the technical or factual competence to make a determination one way or the other. What is sure, however, is that there are existing proceedings. Warrants of arrest have been issued against living people, some of whom are in the public domain, on the question of interference with witnesses. I think prudence dictates that we let that justice process also take its own course. At the end of that justice process, we will be able to authoritatively determine which part of this hypothesis was valid and which part was invalid, after the judges would have, in the fullness of time, applied their mind to the evidence that would have been adduced.
Yes. Do you see the Chief Prosecutor appealing this? Because the question is, her case in as far as witnesses largely crumbled. She cannot use recanted evidence, which she argued she needed to be able to move forward. Is it prudent for her to appeal?
An appeal is one of the options available to the prosecutor. And the challenge we have as officials bystanders who observe these proceedings from outside is that a bulk of the material we get are recanted material. A lot of things are removed for the sake of security of witnesses, and therefore we don't have the benefit of the full material to say, yes, looking at the full material before the court was right or the court was wrong. However, Again, professionalism and prudence dictates that we must defer to institutions. A court has made a finding that there is no material before it that can warrant putting of the accused persons to their defense on a majority decision. There is a dissenting decision that thinks that no, this case was not so broken that if no further material were adduced by the defense, the court could not have convicted. Probably the prosecutor could study the reasoning by the dissenting judge and see whether it is the line of reasoning that it could get a majority on at the appeal chamber and make a determination whether or not to appeal. But I think, so that's one of the options available. The other option is for the prosecution to await, because the main reason why the court chose not to acquit William Ruto and Joshua Rapsang was because of this hanging question of witness interference. And those proceedings are still pending until the hurdles of getting the suspects to The Hague are cleared.
Yes.
The other option is for the prosecutor to wait for that cause to go its full hog, then to see, in light of the options left, to reintroduce the charges. Can they exercise that option in light of the determination, one or the other, on that question of interference with witnesses?
All right.
I think this will be a time for the prosecutor to regroup and assess her position and decide on which of the options open to her that she's going to take.
Right. Okay. And I want us to continue talking about the victims, because very important. A lot of people took to Twitter to ask, you know, when will justice for the victims be served and be seen to be served, as you speak in legalese. But I want us to listen to the lawyer of the victims. That's Wilfred Nderitu, what he had to say, in saying, of course, first he said that the victims, I beg your pardon, would be disappointed, or rather were disappointed with this particular finding and ruling of the ICC. But let's also listen into what else he had to say.
It is my hope that there will be an appeal by the prosecutor. I can say that I had spoken to a number of victims, just sampling them just to get their views on what they would be expecting. And many of them had expected that this case would proceed to the defense case.
All right, that is Nderitu Wilfred, who was representing the victims in this particular proceeding, saying that as victims they cannot appeal because they were participants and not considered as part, as what are they called? Parties.
Substantive parties, yes.
Parties to this. Let's begin with that question that many asked. Will justice ever be served for the victims?
We are asking the same question, Sophie, and it was a bit emotional watching Joshua Sang speaking with the results of this verdict. Very emotional, and you could see he's clearly very relieved and very happy. And a lot of us are also hoping that the day will come when we will see the victims of the post-election violence of 2008 emotionally also talk about that their day of justice has come. If you allow me very quickly, I would like to say that, you see, in the past we have read and witnessed that quite a bit of money has been availed, about 10 million has been availed for reparations. But I want to suggest that this is but a drop in the proverbial ocean, because it worked only for those who lost land or real estate. And even so, they were compensated at about 400,000 a person, which was quite inadequate for maybe what they would have wanted to do. A lot of people lost businesses and their wherewithal to just make a living. And those who have never been factored in. A number of IDPs were integrated into communities, maybe living with their relatives, etc., and were never encamped or never lived in a camp situation. Somehow they also not factored. And one of the other truths that Kenyans don't know is that there are so many IDPs in this country, and there are a lot of IDPs, especially in the northern corridor, the former northeastern territory of Kenya, Wajir and Mandera, especially with the civil clashes that have taken place and the conflict that has taken place in that part of the country. And that therefore we are so far away from so many Kenyans are so far away from their day of celebration. And with regards to the ADP question, I think we really have, as a country, to embrace it in order to bring the day of justice for so many.
All right.
I would like to maybe also mention that the Truth and Justice report, which came out some years ago, is yet to be implemented, and it provided special mechanisms for implementation.
All right, and we'll be able to talk more about that, including the restoration fund that the lawyer talked about. But let me ask you this, Ongoya, because there are those who argue, as far as the perpetrators that committed these atrocities locally, yes, ICC targeted those that were alleged to have had the greatest responsibility. That has all collapsed so far. Locally, not much has been seen. In March 2011, a report by the DPP claimed 94 cases had resulted to convictions. However, the Human Rights Watch had found only a small percentage of that 94 had been serious crimes like murder, maybe 2 or 3. So is there no recourse in as far as local systems are concerned?
Let me approach it from the bigger question. You know, justice is a very interesting question, and there are various versions of justice. So that one can talk about restorative justice, where you are taking the victim to the position he or she was in before the ills were committed.
All right.
Number 2, there is retributive justice. There's some feel-good effect when you see the wrongdoer also being beaten.
Yes.
I mean, but again, let our listeners not mistake this. We are not suggesting that justice could only have been served by a conviction of these particular people, because the purpose of the trial process was to establish whether indeed these were the persons greatly responsible for the atrocities. So far, the court has established, so to speak, otherwise, because it has found that there's no material that can even put them on their defense to show that they were people who are greatly responsible for that. There are a number of dimensions to this aspect. First, as a country, again, we must reflect. Where does that leave us in terms of a possibility of similar occurrence? This looming question about witness interference. I dare say that I pray it be not true that witnesses were interfered with. Because if it is true that witnesses were interfered with, and that interference with witnesses led to people getting off the hook, then it means that there is an easy way out of the justice process, which can be very dangerous, because it means it can recur, and the same process of interference can take place, and then we can back to square zero. That is something that, as a well-meaning citizen, I would shudder to imagine should happen again in a society that I proudly associate myself with. Number 2, as my colleague has pointed out, I think this far, whether this process came to not because of incompetence on the part of the prosecutor or because of interference, political or otherwise, with witnesses, the biggest loser has been the victim. Because in terms of retributive justice, the victim has been left exposed, that this can happen again. You see, if somebody wrongs you, and you have a forum where you can report them, you can safely tell them, I will report you. But impunity thrives where they will tell you, go again to that ICC and we see whether it will help you the way it failed you last time. Then the victim becomes helpless. That is what I think would culminate in despondency on the part of the victim. I really sympathize with the victims in the Kenyan case. I have personally done some analysis of the Kenyan case, and I have no absolute numbers. But there are few cases in Kericho, in Bungoma, where people were, convicted of some petty thefts and so forth. There were no real convictions of the real atrocities that shook our conscience. The things that shook our conscience were not because somebody passed by a petrol station and ran away with some spare tire that was being repaired. The gross murders that we witnessed really shook our conscience, and so far no one has been brought to book in light of those. If you followed the proceedings at the Nakuru High Court before Justice Maraga in the trials in respect of the Kiambaa Church, and you listen to the side observations the judge made in acquitting those people, because as far as he was concerned, there was no sufficient evidence to convict those people. The judge was disturbed that crimes of this magnitude can be planned and executed in a free society without intelligence systems detecting them, without security systems attempting to prevent them, and without anybody credibly being brought to book to account. And that's the same question that will linger in my mind as I reflect on this ruling today. That the court has found that there's no sufficient evidence that crimes of this magnitude can take place in broad daylight, in a free society, and no one is detected, no one is credibly brought to book to account. Our collective conscience as a country has, to my mind, been punctured.
Right. And Shah, let me ask you then, does this mean for the victims that the official search for accountability is over?
I don't think so. I think there are still mechanisms. First, I have taken the view myself that every country owes its citizens, in fact, the justification for government in any country is first and foremost security of the person, and the person's limb and the person's property.
Right.
And if the government fails that, the person still has recourse privately. And I think, speaking for myself, that victims still have recourse, particularly the cadres that my colleague has alluded to, who never got compensation, to still approach our local courts and ask, what is there in store for me in light of this harm that I suffered? I was raped, I lost my business, I lost my land, I have never been compensated. Can you order the government to compensate me as the primary entity vested with the duty to protect me, to protect my limbs, to protect my property? So there are still options available in our civil jurisdiction.
All right. And yes, you wanted to add something?
Yes, I wanted to say that this question you have asked is a poignant question. It's a fundamental question. And it's a worrying question. And this is what should have us, should bring us to our attention. That, as my colleague says, something so egregious as what we witnessed during the post-electoral violence happened, and in international and local courts, the findings are insufficiency of evidence, inadequacy in investigations, and lost evidence, if there was any, or reluctance of anybody wanting to speak. And the reason is because this post-electoral violence became politically polarized. And the politically polarized issues just evaporates. And then it's like the pain, and we are, as a country, mired in pain and blood. It takes a second or a back burner or a second chair to the political interests of the day. And I think it is on that altar that many have been sacrificed.
Right.
I would say that we lost the opportunity to effectively follow up on local remedies, because there's a satisfaction and a national healing and rehabilitation, if you like, when there's an admission of guilt. And then we can go ahead and talk about restitution and reparation.
Right.
Even the admission that this was done and it is wrong, then even as people are going back to the homes from which they were chased away, they would feel a certain security of returning to their homes. People who are chased away from their homes in the Rift Valley have not returned.
Okay.
Will they ever return?
Yes, will they ever return? Wilfred Nderitu, the lawyer for the victims, saying that government should ensure justice and initiate a 10 billion Kenya shillings restoration fund. Tell me your thoughts on that. I don't know if you've gotten an opportunity to read the statement from the president following this ruling, but one of the things he said is that this particular proceedings have been a nightmare for the Kenyan country, for Kenyans, and that now that the cases have been terminated, they will celebrate on the 16th, as I mentioned, of this month in Nakuru, and saying that, you know, they campaigned on that coming together of different tribes that were seen to have been in conflict at the time, and that they'll continue to build on that. So are you convinced, one, there'll be this restoration fund being initiated, and reparations, as well as real reconciling and bringing together of communities? That's real and not political.
I mean, that's a difficult question for me
Yeah.
as to whether the fund would be set up.
Yeah.
It depends purely on the wielders of political power, the managers of the purse of the state, to determine how to allocate the resources of the state, and that's one of the options available to them. But more importantly for me, Sophia, is this, that when we celebrate on the 16th of
What will we be
April, the year
celebrating?
2016, what shall we be celebrating? I want to reflect on the opening statement by my learned colleague Kioko Kilukumi when he was making the opening remarks at the pre-trial chamber proceedings for the now Deputy President William Ruto. He observed that it is true that towards the end of the year 2007, the devil visited Kenya. The question is, at whose invitation did the devil visit Kenya? I think we would have had a much more genuine celebration if we had unraveled that mystery of who is this mysterious person who invited the devil to visit Kenya at that point in time. That question remains pending outside there, and therefore to celebrate would require a measure of reflection. It should be an occasion we shall reflect as a country. It is true, I think the president as a symbol of national unity is justified in insisting that we need to invest in mechanisms that bring us together as a nation. But whether the happening today is the mechanism that brings us together as a nation is a matter that is at large, but a matter that I fundamentally doubt is one that brings us together as a nation. It is a day when more questions have been left unanswered than the questions that have been answered. And as a well-meaning nation, as a nation that has concern for others, in this case I mean the victims of the post-election violence, we will do better to reflect and soul search than to go and make merry.
I'd also dare to add, with your kind permission, Sophia, that look at the elections, simple elections at a university, causing closure, and the riots and mayhem. If that's a microcosm of our society. And if that is the kind of effect and the pictures we are having on our screens about that level, magnitude of violence as a result of bungled elections at a university for a student's body, I think we should be much worried about the possibility of the same kind of eruption. And in 2013, the ICC cases, we were very close to them. I think they were live, and there was a sense of let's be responsible, let's not react. But I think if you look at the political rhetoric that is flying around and the kind of conversations that are taking place even in social media, I think there is a quick forgetting of what happened in 2008.
Which brings me to my question. You know, you've built up to it in as far as we have the political rhetoric, we have the IEBC credibility has been bashed and declined greatly. We have the Supreme Court that decides a presidential election dispute, as well having its own credibility issues in terms of integrity. So was ICC then in vain? Because those would argue this should have been a process that if anyone ever thought of committing this kind of atrocities, this is a deterrent. So would you say that was in vain? In light of an IG who is saying there are groups, there are gangs that are regrouping ahead of 2017?
The ICC process was not in vain, as far as I'm concerned. A justice process has taken its course and has come to an end. It is we the people to ask ourselves, what lessons have we gathered from that process? The ICC as an institution is an institution that ought to exercise its jurisdiction with a sense of responsibility, and it could not have convicted a human being for the sake of conviction. It could not have convicted for the mere sake of sending a message. It was under an obligation to convict in accordance with the rules of evidence, in accordance with the rules of trial, in accordance with fair trial guarantees, and so forth and so on. And it has applied itself up to today's verdict. and the process is still open in case appeals are preferred or in case other proceedings are undertaken, and we will comment on those as and when they occur. It will be very unfair to that process to declare to have been in vain for a number of reasons. One, in the year 2013, as we went to elections, there was minimal recourse or to violence, and part of the explanations was because of the ICC process. People now knew. And by the way, let's face it, in the year 1992 there was election violence. In 1997 there was election violence. And people were displaced. No one was brought to book to explain anything. This is the first time perhaps that somebody was told, you come and explain something, even if it ended where it has ended. At least there was some motion. We showed that, yes, it can happen. You can be caught, as it were. But as a country, I must also reflect that as a fairly reasonable Kenyan, I believe I am, I have been thinking on recent trends in this country. And I want to take advantage of this rare opportunity I have to tell it to the nation. We are doing very badly. Our mechanisms of cohesion, I think, are at their weakest. The level of recklessness in this country, just look at the level of theft. Everything goes. Look at the level of irresponsibility in institutions. You hear about the happenings in parliament. You hear about the happenings in the judiciary. You hear about the happenings in the universities. Literally everywhere, the things you hear about are very discouraging until you wonder, so who is that torch that will shine this country out of this state of hopelessness? So it is incumbent upon every citizen to know that the responsibility is ours, and to reflect on other societies. History can also be learned. We can also learn from the failures of others. The societies like Somalia have tried experimenting on what we are doing now, and they are doing very badly.
Okay.
And that if we continue along the path we are doing, then we will end up the way they have ended up. So it's important that people out there reflect on this country and begin a conversation around how to remedy the ills of this country. Otherwise, the things that are happening here, I'm very afraid, speaking for myself.
Yeah. You wanted to add something?
Yes, I would like to take up where my colleague has left off and talk about public institutions. And I say that public institutions must remain accountable for inaction that may be opening gates for incitement at this point. Looking around, I don't know whether you have seen it, that a number of people have put up real big billboards, and we would think that we are already in campaign mode. And yet, campaigns have to be reined in, so that it is, we are told this period now, we have opened campaigning, and this is the end of campaigning. And I think the space is now open for anybody on the campaign trail to use this time to disenfranchise Kenyans and incite them to violence if they please. I think various independent institutions must really deal with violations and curb these violations insofar as they are happening. I think also Kenyans must be very aware that we are individually responsible for what we put up on our social media sites and kind of messages that we are bouncing off, irrespective of the fact that we may not be the authors of that. These are the things that ignite incite people. And right now, in fact, as I was coming to studio, one of my staff members called me and told me that a lot of gory pictures and photographs and videos are really, they have really been hitting social media since the pronouncement of this case today. And I think that we have to be very, very careful as Kenyans. Each has to do their part. Each has to do their part to ensure that we are not the inciters of others, and we do not excite violence, which will then come to wipe us all out.
Yes. I want us to take a look at more reactions that came in after the ruling from the International Criminal Court, some of the leaders, and what they had to say.
At long last, after 6 years of our tribulations at the ICC, justice has been done.
All right, the leader of majority there saying that justice has been done. I understand we have more comments from other leaders who gathered at William Ruto, the deputy president's official residence in Karen, to celebrate with him this news.
ICC issues has been binding us. So minus ICC, I think we are free to go.
The role that Uhuru has played, even if it's a small role, towards his acquittal. And therefore, it then even gives him more incentive to stay in the Jubilee coalition.
He'll want to go into the 2017 elections with his sight trained on the 2022 election.
Of course, this one's not from Ruto's residence, but a cross-section of leaders there and a political analyst, Javas Bigambo, giving their thoughts. Mongo, I'd like to just get your political inclination as far as the implications of this ruling for Jubilee briefly, because there are those for a long time who'd said the president, after he was let off, was not really paying much attention to the deputy's case, but now it's all good, or is there still this likely to bring tension in any way?
Well, let me first of all address a broader question, Sophia. You know, celebrations in the short-term sense are not necessarily an unexpected thing. There are two reasons why we celebrate. One, if you genuinely win a process, you have every reason to sigh with relief and celebrate it. Yeah. Two, if you go through a close shave, you also sigh with relief and celebrate. Whichever you look at it, you'll see that it's not all condemnable that anyone will take on to celebratory mode. But talking politics, I think this would obviously strengthen the relationship between the Honorable Uhuru Kenyatta, President, and the Honorable William Ruto, Deputy President, because they have walked through a problem together. And there is something that is spiritually binding when you go through a crisis as a team and emerge out of the crisis as a team. Your relationship, I think, gets a stronger bond, as it were, and I think there will be merit in that, because I think the two stood by each other. In public pronouncements, unless there were some things in the background that I didn't perceive or others didn't perceive, I think in public the two stood by each other, spoke for each other, and fought this battle together. The battle brought them together in 2013, and they have walked out together in the run of 2017. I see this solidifying their friendship, their personal friendship, their family friendships, their political friendships moving forward.
All right, let's go back to the International Criminal Court as a court. And there are those who'd argue, and for a long time we've had these sentiments, that it has a bias against Africa. So the question is, does this ruling shed off that tag of bias against Africa? Because ICC Outreach Coordinator Maria Kamara said earlier that this ruling shows independence and impartiality of the court cannot be put to question, as we've seen happen in the past. Do you agree with that?
I would say that I was of a different view in terms of the court being biased against Africans, myself. And I think that the Kenyan cases ended up in ICC as a result of choices that were made consciously, not by people of non-African origin. So I would say that maybe we need to re-examine that particular perception, because perceptions are just that. They are perceptions, and sometimes they are also helped by what kind of quagmire you find yourself in. I wanted to maybe also buttress what my colleague has said in terms of in terms of where we find ourselves right now. I don't think we are necessarily in a good position, and I think we have discussed that in the last couple of minutes.
Right.
But at the end of the day, when you when you have been driving recklessly and you avoid a major accident and you escape with your life, you really sigh with relief. But unless you stop driving as you are driving, you continue to be at risk. And I think as Kenyans, we have to be very responsible with the power we wield with our votes.
Okay.
Because if we continue the way we have done in the past, we will always end up in crisis because of our democracy is still very fragile.
Okay, I'm going to have the same question to you, and also putting into context not just the Kenyan matter, but the allegations that have been, put out against the ICC as far as its interactions with all the countries and how it practices it.
One thing I like about politicians and political statements is how they are episodic and meant for the moment. For example, one of the people I've seen claiming justice has been done is the Honorable Duale. Justice has been done by who? Because again, Duale is foremost in your recording clips alleging that the ICC is a political institution that cannot deliver justice. So who has done justice? The same ICC. I mean, those statements are meant for that moment. I do not believe that the ICC was at all biased against Africa. I mean, let's face it. Let's not be our brothers apologists. Atrocities have happened in Africa. If you traverse this continent, you'll understand that I don't think there's any other place in the world that witnesses more atrocities than Africa as a collective continent. That is not so that other societies are perfect. But again, if you examine other societies, they do their best to do something about their situations. Africans are the only people who something happens and you look at it as if nothing happened, you move on. Number 3, if you look at the ICC cases the case African ICC, all of them were referred by Africans to the ICC. They are not cases that ICC assumed jurisdiction over forcefully, except 1 or 2 out of all the situations that are there. The Kenyan situation, you will remember, and unless we want to learn history, we say it ourselves. Let us not be vague. Let us go to The Hague. We said we want to go there. How can we turn around and say, no, we found ourselves there because they are biased against us as a continent? So I think to an extent we are hypocritical as a continent. We must agree that we have a problem as a continent. These problems are ours. We don't want to blame others.
Unless we deal with it,
if you don't deal with problems in your home and you keep blaming your neighbor, you will remain with those problems, whether you like it or not.
Elisha Ongoya, who's an advocate of the High Court, and Kagwiri Ambogore, who's the chair of the Kenya National Commission on Human Rights. We thank you both for joining us on The Last Word tonight. It has come to pass. The last of the 2 cases of crimes against humanity arising from the 2007-2008 Kenyan post-election violence has been terminated by the Hague-based International Criminal Court. Now, consequently, both President Uhuru Kenyatta and his deputy William Ruto can forge ahead with their political careers and specifically indulge in 2017 general election campaigns without the burden of ICC cases, unlike when they campaigned for presidency the last time. But amid the celebrations from Kenyans and particularly Jubilee supporters begs the question, where does all this leave the victims of the post-election violence? Whereas justice has been served following the court process, it is a prayer that after the celebrations, the country will continue with a healing process that would go a long way in making the post-election violence victims cope with a ruling which, as their lawyer Wilfred Nderitu said, didn't go as they expected. And that is The Last Word. Thank you for watching. Have a good night.